Hi, everybody. This is Advocate Lucinda, your empowerment lawyer. I had a mother to contact me. Her child is in the custody of the state, and the child has a guardian ad litem that the mom would like to have removed. And I thought that was a very interesting situation and worth making a video on. You know why? In my early days practicing law, I worked as an attorney with the juvenile court. I was appointed as an attorney sometimes for the child based on truancy and some other issues, parental termination when the court moved to terminate the parental rights. I often represented the parent. Then there are other times when the court puts the child in the custody of the state in adoptions, child abuse and neglect cases, child support, so on and so forth. So I know the painstaking situation mom and dad is in when the child is removed from the home for whatever purpose. And I'm sure there are other moms and dads who will benefit from this video because they probably want to remove their guardian ad litem as well. Okay, so let's get into this. Motion to remove the guardian ad litem when the guardian ad litem is biased. And this video is going to focus on evidence to look for when the parent is considering filing a motion. Because I can tell you at the outset, it's very difficult to have a guardian ad litem removed. So the circumstances have to be severe enough where the court deems it necessary to remove the guardian ad litem. So let's get started. The top priority in this matter is about the child's well-being. Mom, I think you'd agree with that. Dad, I think you would agree with that. And we're hopeful that the guardian ad litem agrees with that. And I can say, having been a guardian ad litem, most guardian ad litems really do care about the well-being of that child. And we're going to see where some don't, but for the most part, they do. So, in the situations where a child has been removed from the parent or parents, life happened. And there are many reasons why a child is removed from the home, and they are not good. Let's just keep it real. And this is not to judge a parent. And if you are a parent and you're in this situation where your child has been removed from your home, don't judge yourself. What you do is assess the situation. I have also been on the other side where I represented the parent whose child was removed from the home, where I communicated with the guardian ad litem. So, mom, dad, make sure that you are communicating with the guardian ad litem, whether it's through your attorney or whether you're on your own. Make sure that the guardian ad litem understands you and your wishes and your desires. Be proactive, whether you have an attorney or not. As an attorney, having practiced law for 28 years, I love it when my clients are proactive. It makes the process feel open and the parent feel like they have some ownership in this. That's the way you need to feel when you're in a situation like this. Follow the plans of the court. And if you feel like the court has included an item in the plan that you have difficulty with, you make that clear to your attorney. Or if you don't have an attorney, you make that clear to the court. Be proactive because you want to do everything that you need to do to prevent having to file a motion to remove the guardian ad litem. And if you find yourself needing to file the motion, at least you can say, I've done everything I needed to do to prevent this from happening. I just wanted to get that out there. So let's get into the substance of this video. The juvenile court has jurisdiction over these matters. So when a child is removed from the home, the court, in essence, places the child in the ward of the state. And the court appoints a guardian ad litem to act on behalf of the child. The guardian ad litem's job, in a nutshell, is to collect information relevant to the question of the child's best interest, and report that information to the court and the parties' attorneys. Having said that, I wasn't just born yesterday. I understand and have seen guardian ad litems who have not been fair in the process. A guardian has acted what seemingly is unfair. It doesn't mean that it meets the conditions for the court to remove the guardian. That's why I stress moms and dads to communicate with the guardian ad litem. What is bias? Bias is prejudice in favor of or against one thing, person, or group compared with another, usually in a way considered to be unfair. In order to prove bias, you would need to show that based on the facts at hand, no reasonable guardian ad litem could or would take the actions the guardian ad litem has taken. So let's look at some examples of a guardian ad litem being biased. And we're going to get our examples from a case that the American Bar Association cited. The case is in regarding Snohomish County VGAL, and it's regarding guardian ad litem. The ABA made a really significant statement here. It says the goal of a dependency case is almost always reunification of the child with his or her parents. And that is true. That is the main focus. Even though the child has been removed, the system must make an effort to reunify the child or children with the parent or parents. The ABA goes on to say services and treatment are to be provided so that reunification can happen quickly, understanding that children do best with their parents. And this is true. Yet, despite these clear goals, the VGAL program was found to have consistently disrespected parents and undermined the goals of reunification, particularly for low-income parents. And I can say amen to that because I have witnessed it. So let's look at some bias examples that the ABA identified. When the guardian ad litem fabricates report to prevent reunion of the parent and child is clear bias. Mom, dad, ask for a copy of every document that is made in the case. Now, there may be some documents you may not be entitled to, but you want every document that has been created in that case. You want to read the code to determine what the guardian ad litem's powers and duties are. Another example of bias is when the guardian ad litem leaks private and confidential information to non parties. And I can tell you what that is. That's to garnish a situation where they can justify non reunification or to garnish support to prevent reunification from happening. Where the guardian ad litem destroys evidence. I know it sounds unreal, but it happens. That's why it's good to know what documents are being gathered in the case. And mom and dad, you get in a copy of each document. Keeping in mind again that there may be some documents you're not entitled to physically, but you need to know they exist. You have that right. Another example of bias that the American Bar Association pointed out in the case, the guardian ad litem never visits the child, particularly where the guardian ad litem is making reports but has not visited the child. That's borderline fraud. And the ABA pointed this out in this case that is cited. And there's document dumping. This is a big one that as attorneys we experience, as at least plaintiff attorneys and plaintiffs. And some of you have, I know you've experienced this document dumping. What is document dumping? The document dump is a well-known abusive litigation tactic, often used in large civil litigation involving corporations or government entities. Document dump is defined as the act of responding to a request for information with a large quantity of data that is transferred in an unfriendly and hostile manner. And you know what they're talking about. They just give you the stuff. They send it to you. There's no order. They don't have to put it totally in order, but it needs to be sent in a manner that is friendly, where it has some distinction between what is what. It may be used to hide unfavorable evidence, this is true, by mingling responsive documents with a large number of non responsive documents. Document dumps often produce more information than requested. This is true. And many of you have seen this. I know you have, because I've talked with some of you, and you've seen this in the discovery production that the defense presents. So it is unorganized or unlabeled format. So true. The producer or the defense counsel then argues it's done the recipient a favor by producing more than requested. Now, initially, this is not the guardian ad litem's job to unravel this document dumping, because the documents goes to the attorneys who represent the mom and dad of the child who has been removed from the home. But what happens when the mom and dad is not represented by counsel? Mom and dad, more than likely, is not going to understand these documents. Coupled with a guardian ad litem who is biased, can you imagine the overwhelming defeated spirit has now accepted? And the guardian ad litem is not helping? And that's a tragedy. Mom, dad, here's the key. Be proactive in the process from A to Z. Preferably, if you could hire your private attorney, that would be good because the private attorney is not appointed. Now, a lot of times, I know some people are not going to like this, but a lot of times appointed attorneys supposedly is speaking for the client, but really they're speaking for the court. The acts that a lot of these appointed attorneys or appointed Guardian Ad Litems, no, they're going to do what the court wants them to do or what the opposing counsel wants them to do. If you cannot afford your personal attorney, call legal aid. Call the state bar and ask for a list of pro bono attorneys that you can call and ask if they would work for you on a pro bono basis. I'm going to leave a link of the American Bar Association case for you to read because it cites other acts that they found was bias. So I hope this has been helpful to you, mom and dad, particularly those who are not represented by counsel, but get your counsel. And those who are represented by counsel, just continue to communicate with your attorney, but be proactive. Okay? All right. I'm Advocate Lucinda, your empowerment lawyer, and we'll see you next time. Take care.